Recent years, the use of private prosecutions in the UK has come under intense scrutiny. While the right to bring a private prosecution is a long-standing constitutional safeguard, concerns are mounting about its misuse, especially when private interests intersect with the powers of the state. This video explores the risks, implications, and calls for reform surrounding private prosecutions, focusing on the case of Mark Cohen and the broader justice system. We'll examine how these prosecutions can impact civil liberties, due process, and public confidence, setting the stage for a deep dive into the heart of the matter. Right to initiate a private prosecution has deep roots in English law, originally designed to ensure justice when state authorities fail to act. However, the modern reality is more complex. Increasingly, corporations and wealthy individuals use private prosecutions in ways that may not align with the original intent. This shift raises questions about whether the system still serves the public interest or has become a tool for private advantage, potentially undermining equality before the law. Private individuals or organizations initiate criminal proceedings, they often have access to expensive legal teams and specialist investigators. This creates a significant imbalance, especially for ordinary citizens who may lack the resources to defend themselves. The accused can face reputational harm, psychological distress, and financial pressure, regardless of the outcome. Such disparities challenge the principle that justice should be equal and impartial for all. One of the most troubling aspects is the blurred distinction between private prosecutors and the Crown Prosecution Service (CPS) once proceedings are underway. In theory, the CPS should maintain independent oversight. In practice, however, the transition from private to state prosecution can create the perception, or even the reality, that state authority is reinforcing proceedings initiated for private purposes. This undermines public confidence in impartial justice. Criminal prosecution carries consequences far beyond civil litigation: arrest, loss of liberty, criminal records, and reputational destruction. These powers must be exercised with caution and independence from private motives. Yet under the current system, there is often insufficient separation between private complainants and public authorities, raising the risk that criminal law is used as a tool for private gain. When private prosecutions shape the evidential framework and narrative before CPS involvement, genuine independence becomes difficult to maintain. The CPS may inherit assumptions and strategies formed by private actors with vested interests. Even with professional conduct, the appearance of continuity between private and public prosecution can erode trust in the justice system. Growing concern is the use of private prosecutions as leverage in civil disputes: financial, commercial, contractual, or family. The criminal law should never be a bargaining instrument in civil matters. Yet, allegations of wrongdoing are sometimes deployed strategically to gain advantage in negotiations or settlements, turning the justice system into a tool for coercion. Even when charges are dropped or dismissed, the process itself can be punishing. Careers may be destroyed, reputations tarnished, and families destabilized. The psychological impact is profound, and for many, the ordeal of prosecution is a punishment in itself. This reality highlights the need for safeguards to prevent misuse of the system. Powerful corporations and wealthy individuals can fund extensive private investigations and prosecutions, creating a system where access to justice depends on financial power. This undermines the principle of equality before the law, making it possible for those with resources to initiate criminal proceedings unavailable to the average citizen. Current framework risks violating rights protected under the European Convention on Human Rights, including the right to fair trial and respect for private and family life. When prosecutions are closely tied to private disputes or strategic pressure, questions arise about necessity, proportionality, and whether actions are truly in the public interest. Unlike state prosecutors, private prosecutors may not be subject to the same practical safeguards or oversight. Recent cases have collapsed due to failures in disclosure or concerns about fairness. These are not hypothetical risks, they are real and substantial, highlighting the need for robust accountability mechanisms. Problems extend beyond individual cases. Patterns emerging from multiple reviews suggest systemic issues requiring urgent scrutiny and reform. The volume and consistency of concerns indicate that this is not merely a matter of isolated error, but a sign of deeper flaws in the legal framework governing private prosecutions. Lawrence Kurt solicitors and others are calling for comprehensive review and reform. Key recommendations include greater scrutiny and transparency when the CPS takes over private prosecutions, stronger safeguards for procedural independence, enhanced judicial oversight, and statutory protections against using criminal proceedings as leverage in civil disputes. Psychological toll of criminal allegations can be immense. Even without a conviction, the fear of prosecution, media exposure, legal costs, and the threat of imprisonment can force individuals into settlements or concessions. This dynamic risks turning criminal law into a bargaining instrument, rather than a mechanism for impartial justice. There's a pressing need for clearer public guidance distinguishing legitimate criminal enforcement from misuse in civil contexts. Citizens should not fear that ordinary disputes may escalate into criminal proceedings driven by private agendas. Transparent guidelines and oversight are essential to restore public trust. Related concern is the use of private investigators and security companies by police forces. Outsourcing investigative functions to private entities raises questions about accountability, authorization, and evidential integrity. The regulatory framework must ensure that such practices do not circumvent established safeguards or undermine individual rights. Evidence gathered by private actors must meet standards of reliability, lawfulness, and admissibility. If evidence is obtained outside the established authorization framework, its integrity is questionable. Full disclosure and transparency are vital to ensure fair proceedings and protect the rights of the accused. In cases like Operation Granite, the involvement of private investigators in evidence gathering, surveillance, and witness management demands rigorous preservation and disclosure of all relevant material. Any attempt to alter, destroy, or conceal evidence can have serious legal consequences and further undermine trust in the justice process. Defendants and their legal representatives have the right to formally challenge prosecutions on grounds of procedural fairness, admissibility of evidence, and abuse of process. Courts are invited to scrutinize the legality of evidence gathering, chain of custody, and disclosure practices. Where fairness is compromised, proceedings may be stayed or evidence excluded. Oversight bodies such as the Attorney General's Office, the Investigatory Powers Commissioner's Office, and the Administrative Court play a crucial role in reviewing practices, issuing guidance, and ensuring that justice is administered fairly. Their involvement is essential to address systemic issues and restore public confidence. Credibility of the justice system depends on fairness, restraint, and public trust. Private prosecutions may serve legitimate purposes, but where there is potential for abuse, reform is essential. The law must evolve to protect both complainants and the accused, ensuring that justice is not a commodity for the wealthy but a right for all. Urgent consideration and action are needed to maintain the integrity of the UK's legal system.